to be here, just because what you all are doing in practice, focusing on details, is a spiritual truth of our country.
You know, we can be Democrats and Republicans, but most Americans are patriots.
For over a decade now, good ideas have emanated from the BPC.
Thank you for convening this very impressive group of thought leaders.
Your organization has brought together leaders from across our society to advocate for common sense solutions to our most challenging problems.
Because if it's bipartisan, it's much more likely to pass.
When you have people philosophically and ideologically in two different worlds, and they put them together on a committee, that committee usually is not very productive. Once we get staffs blending, and John and I, they know that the members are friends and we talk, things can happen.
Thank you, Anand, for that introduction, and to the BPC for its important efforts.
Thank the Bipartisan Policy Center. You guys are great.
We all have bipartisan responsibilities to this nation to defend principles that have long made America the beacon of hope.
It's going to take all of us to try to turn down the temperature and really focus on what unites us.
Good afternoon, and welcome to the Bipartisan Policy Center's virtual event on the expanding mandate, immigration, and the courts. I'm Teresa Cardinal Brown. I'm Managing Director of Immigration and Cross-Border Policy at BPC. Anyone who has followed immigration issues over the past 5 or 6 years, even in passing, will have noticed a seeming increase in headline-grabbing immigration stories about federal courts stopping administration programs or policies on immigration. Several high-profile Supreme Court cases on immigration have come down on significant policies and programs initiated by President Obama on DACA and DACA expansion, President Trump on travel bans and ending DACA, and President Biden on the Remain in Mexico program, to name a few. Just yesterday, the Biden administration issued a final rule meant to fortify the DACA program against current litigation. However, most experts do believe that it's unlikely to go into effect because certainly the state of Texas, which is currently suing the government over the legality of the program, will ask for it to be stayed. Those of us who've been in the immigration policy world for a while find this new generation of federal litigation substantively different from the kinds of court cases that have dotted most of the history of immigration policy in the 21st century. One aspect of that change is who is suing the federal government, namely states and their attorneys general, often with a partisan angle. Republican states are suing Democratic presidents and vice versa. Another aspect is the use of nationwide injunctions by federal district court judges who, with the stroke of the pen on an order, can halt or restart a program overnight across the country. And all of this has come at the same time that Congress seems to be unable to pass anything with the word immigration in it. So what does all of this court action mean for federal immigration policy? Who is really in charge of deciding what U.S. immigration policy is anyway? And what does the future hold? To help us address those and other questions, we have a wonderful panel of legal experts today and an excellent moderator who I'll introduce now. Ellen M. Gilmer is a senior reporter at Bloomberg Government, covering the Department of Homeland Security and its agencies, as well as covering federal policy on immigration. Previously, she was a senior legal reporter for Bloomberg Law and has spent much of her journalism career covering regulatory issues and federal litigation, which makes her the perfect person to moderate our panel discussion today. I'll let Ellen introduce our panelists and kick off the conversation, but first, just a note, you can participate in today's event by using the comment section of the YouTube page, or on Twitter by using the hashtag BPCLive. Our team will be monitoring those feeds and will pass along your questions to our host. And so now I turn it over to Ellen Gilmer to start our conversation.
Thanks so much, Teresa, and thanks everybody for joining us today. As Teresa said, it's kind of a wild time to be tracking immigration policy and immigration litigation. Those of us who are following all of the news in this space kind of some days feel like we have a sense of whiplash. There's a lot going on. There's very active court dockets in this space, and we are very lucky to have such a good group of folks who are here to give us their insights on it. And I will say, for me, it's been so helpful to learn from all of these people, either from talking to them directly, following their feeds on Twitter, following their work. It's just, they've got their finger on the pulse of what's going on in the immigration policy and litigation space. So our panelists today are Leon Fresco. Leon is an immigration attorney at Holland & Knight. He's a former Justice Department lawyer who was the Deputy Assistant Attorney General for the Office of Immigration Litigation, which is part of the Civil Division. Leon provided litigation risk assessment to cabinet members in that role, and also oversaw civil litigation on immigration in that role. So he's got some great perspective for us on that and in his private practice. Then we have Professor Ilya Soman. Ilya is a professor at George Mason University. His research is really diverse. He is an expert on constitutional law, property law, democratic theory, federalism, and what we're all talking about today, migration. Ilya has a book called Free to Move, Foot Voting, Migration and Political Freedom, which is a really interesting read. Then we have Karen Tumlin. Karen is the director and the founder of the Justice Action Center. She is a nationally recognized impact litigator who's focused on immigrants' rights. She is involved in a lot of the big cases that we are all following, and has a very good sense of what's happening in the courts and what's happening within the immigrants' rights movement. She has litigated on some high-profile issues, including the DACA program, which Teresa just mentioned is in the news again today, and the travel ban. So thanks to everybody for joining us today and offering your expertise. And again, as Teresa said, please do offer up your questions in the YouTube channel or on Twitter. So to get things started, I wanted to kind of take a step back and look at how the immigration legal landscape has evolved, or sort of where it is and in its journey. I want to first turn to Professor Soman because he has a really good sense of kind of where the courts really are on this. We're all so busy all the time tracking all the litigation, and it seems really insane with all of the action coming from the courts. But I think, Professor Soman, you can give us a little bit of context for how aggressive the courts are actually being in this space. We're not. Ilya?
Yeah, thank you. As Teresa said, there's definitely been more litigation in federal courts over immigration policy issues over the last several years than perhaps earlier. And in some respects, courts have become more active. I think some of the other panelists are going to talk about some of the ways in which that is the case. But I'd like to start off by noting that there is an important sense in which the courts are actually very weak and relatively permissive in this area towards the government. And that has not changed over the last several years, and indeed may have become worse in that in a wide range of issues, the courts have to a large extent exempted government immigration restrictions from constitutional constraints that apply to virtually all other exercise of government power. There are many examples of this. The most famous in recent years is the travel ban case, where there was overwhelming evidence that the motivation for Trump's actions on that policy was anti-Muslim bigotry. If there were comparably great evidence on almost any domestic policy, the courts would have struck it down. But the Supreme Court explicitly said that they weren't doing that, primarily because there's such great deference in their view that's due to the government because it's immigration policy. And that's a striking contrast with the way that similar anti-religious or religious-based discrimination is treated elsewhere. And this is just one of many examples. Similarly, we also allow racial discrimination in immigration policy that we wouldn't allow elsewhere. For example, under both the Biden administration and the Trump administration and Obama before them, we have a rule where racial profiling is permitted in immigration enforcement in any so-called border area, which turns out to be any area within 100 miles of the sea or 100 miles of a land border, effectively meaning that some 2/3 of Americans live in these border areas and therefore are potentially subject to officially permitted racial profiling. That kind of racial profiling would not be permitted, or at least not officially sanctioned, in virtually any other area of law enforcement. And in the same way, courts have allowed the use of methods in immigration detention and also deportation, where there's far less due process than would be permitted for almost any other serious deprivation of liberty, to the extent that we even have situations where toddlers, quote unquote, represent themselves in immigration proceedings because they're not entitled to a right to counsel, as they would be, at least in most other contexts where there's something comparably serious at stake. The last area I would like to flag for people's attention, where it's not clear where this pattern of special deference will persist or not, is whether the courts will apply the doctrines of non-delegation in major questions to immigration policy or not. Non-delegation is the idea that there are limits to how much of its power and decision-making authority Congress can transfer or delegate to the executive. And the major questions doctrine is a related doctrine, which says that if Congress is going to give the executive control over some sort of major policy decision, they at the very least have to very clearly state that they're doing that. Major questions and to some degree non-delegation have been at the heart of several recent high-profile decisions. And there are a number of areas of immigration policy where past court decisions and certainly the executive's position have said the president has incredible, enormous discretion over keeping people out if he or she wants to. And in the lower courts, there has been some action applying non-delegation constraints to that. In 2020, a federal district court struck down Trump's coronavirus-era work visa ban in part on these kinds of grounds. What is not yet clear is whether the Supreme Court will apply non-delegation in major questions in this area, or whether they'll create sort of another ad hoc exemption like they've created for a lot of other constitutional principles. I hope they will not, because as you can tell perhaps from my tone in saying these things, I do not believe that this double standard is justified. There's nothing in the text of the Constitution that says it. There's nothing in the original meaning, and it dates back really to the late 19th century to a lot of decisions that were poorly reasoned, and in many cases were motivated by racism, by which I mean that there was actual racial prejudice even expressed in the text of some of these rulings themselves, and not merely just in the background in society at the time. Much more can be said, but I look forward to the rest of the discussion. Thank you.
Great, thank you. Yeah, there's so much to watch there, especially like you said, in the major questions and non-delegation space. So thank you for all of that great context. Leon, I want to turn to you. You've been following all the twists and turns of the recent cases, a lot of the high-profile ones that have been at the Supreme Court and in the lower court. And the courts have started to answer some of these big questions that perhaps were just kind of lying in wait for a long time. Can you tell us sort of what cans of worms they're opening up as they start to answer these questions and what folks should be paying attention to?
Sure. So basically, there were a lot of unanswered questions that began in 1996 with the passage of what was called IRA, which was a immigration enforcement bill that was passed in 1996. And those basically centered around two different concepts. The first concept was when Congress basically wrote that it wanted people mandatorily detained in a bunch of different circumstances. The question was, did it actually mean that even though that detention could go on for many years and without significant judicial review of any kind, or did it actually mean to have some sort of bond hearing or some sort of other checks on the executive's ability to keep people detained? And then the second question was, when it passed this concept of expedited removal, which is what that is when you arrive at the border or at an airport or at a seaport, and you don't have documents that allow you to enter the United States, you don't actually have to technically go through a very long process of removal. You can be removed immediately, except if you have certain rights to asylum or withholding of removal or other things of this nature. The question was, what are the due process rights of people in that expedited removal process? And so for about 20 years, the courts danced around these questions quite, I think, deliberately, because they thought these were very, very serious questions and they didn't really want to start dealing with them. And now what you're starting to see in the last couple of years, you start with a decision by Justice Alito in an expedited removal case called Judicial, where in that case, the court basically takes the standpoint of even if you entered the United States, because we've always known that if you were outside the United States, your judicial review was basically non-existent. But even if you entered the United States, if your entry is recent enough, and the court leaves this open, so this is one example, how recent does your entry have to be? You don't have any due process rights now, according to the Supreme Court. And so the question is, where is that going to manifest itself moving forward? What we know is in one specific case, it says that means you don't have a due process right to go to the court to challenge a determination that you don't have a credible fear of persecution. But is that going to be applied in many other contexts? Is it going to be applied in terms of your rights to be free from abuse while you're in immigration detention? Is it going to be taken away so you can't challenge if someone needs an abortion or other things of this nature? And so there's a lot of context once you start saying that people who recently arrived at the border don't have any constitutional rights, that it's going to be a lot of open questions that opens up, and we don't know the answers to those questions. Same thing with detention. There was a movement right at the end of the Obama administration to have judicial decisions that were quite broad in limiting the executive's ability to detain people and for immigration purposes. And what the courts have done is basically rolled all of that back, saying no two immigrants are the same. They all have different contexts of cases, so we're not going to apply any rules that are universally applicable to foreign nationals in immigration detention. You're going to have to come in individually and say that your detention is unconstitutional as applied, meaning I've been detained 10 years, can I get a bond hearing? I've been detained 7 years, can I get a bond hearing? And so this is going to be a much longer process now to develop the constraints and the contours of what is a constitutionally unacceptable detention period. And so those are just two examples. There's others, but time is limited. One thing I did want to say is the reason you're seeing many more of these cases is because President Trump actually did something, for whether you agree with him or not, that was actually non-existent with other administrations, which was he opened up the spigot of regulation at DHS. Before, if you asked DHS to promulgate regulations, that was like asking to move mountains. It was something that was unheard of. They didn't do it because it required such an administrative effort of many different branches of DHS to come together to make a regulation. But once that process was streamlined and made much easier to have regulation, the regulation started flowing. And then that led to a ton of litigation. And then in the effort to undo the regulations, that's leading to a ton of litigation. And so now I think we're going to be seeing this for time immemorial to come as administrations go from back and forth. Now that there's much more policy administratively coming from these agencies, which was not the case in the past, that's why you're seeing so much litigation now.
Interesting. Yeah. And the agency definitely is busy. Just yesterday, we talked about the DACA rule. They've got a new public charge rule that's probably coming out soon. So you're right that they're very busy putting pen to paper on the regulatory space. I want to turn to Karen. Karen, it's hard to say how a lot of this litigation is going to turn out. Leon has laid out all of these new open questions that have come up in these cases. What lessons can we take from just the previous Supreme Court term, where not everything landed exactly how a lot of expected?
Yeah, I think, thanks so much for asking. This Supreme Court term is really an interesting one. We have, of course, a changing court, and we'll have a new justice as we start the new term. But one of the cases I was most closely familiar with is the Remain in Mexico challenge. That's a case in which the state of Texas sued the Biden administration for undoing a Trump policy. Now, of course, we all know, of course, a new president can undo a non-statutory program of a past president. The question is, did President Biden's administration do that in the correct way? And this case becomes the standalone progressive win of the Supreme Court term. Of course, not because the Supreme Court is really fixated with immigrants' rights or the rights of asylum, but because of how the case, I think, comes up through the system. And I think there's a couple of important lessons to be gleaned from this. I think the first is it's really narrow and myopic of us to look at any of these cases as subject area containers. The Remain in Mexico case, I'm motivated to participate in that case because my commitment is to asylum seekers and to our legal and moral obligations to welcome asylum seekers, regardless of their country of origin or color of their skin. But when the case makes itself to the Supreme Court, that is not the only issue at play. The outcome is not simply where does it leave our asylum policy, but you have to think about what the justices are deciding as a question of administrative law that has impact on prosecutorial discretion within the criminal context, as a question of administrative law that really goes to the core scope of executive powers, a question of administrative law that goes to the executive's role in foreign policy negotiations. And when you approach the case in that way, the likelihood of your vote outcome completely changes. And what we saw is what was motivating the justices in part to say, this is nuts. We have to reverse the lower court decisions here and allow the termination memo from Secretary Mayorkas to go into place. What motivated them was the notion that a district court judge in the state of Texas could force this administration to negotiate with a sovereign government, the government of Mexico, on one data point, on the Remain in Mexico program, not the panoply of issues that we regularly negotiate with the government of Mexico on. And so you see that in the outcome. The last thing that is important to note in this case, and in many of the cases of the term, is the Supreme Court is willing to step in when they see what they think is gross overreach by the lower courts. And the Remain in Mexico decision at first glance is either a 5-4 or a 6-3 on the merits decision, depending on how you look at it. But if you dig a little deeper, you see that it is a 9-0 decision, with every single justice saying the district court here lacked the authority to issue the injunction that was issued in the first place. And that's where I think we're going to see the Supreme Court weighing in the future, whether it's immigration or what would be considered other progressive causes, when they think they need to stop what is gross overreach by the lower circuit and district courts.
Great, thank you for all that insight, Karen. And you mentioned Texas. I want to talk about Republican AGs, Democratic AGs, the extent to which over the past several administrations they've become better at organizing coalitions, recruiting really top-notch legal talent to their offices, and in some cases very sophisticated in the court. People might argue over which cases are sophisticated versus not, but they've definitely been more active. So, how has that played out in the immigration context? How meaningful has that been in that space? And have, in this most recent wave of immigration litigation, have the Republican AGs who are challenging Democratic policies from the Biden administration, have they been more or less, successful than we thought they would be? I'm going to open that up to anybody who wants to weigh in.
I mean, well, I'll start, I guess, which is to say that, yes, I think it's a dramatic new change, which started, at least in the immigration front, the earliest case was the DACA case, where in 2014, when President Obama tried to expand the DACA program to give deferred action to the parents of people who had DACA status, which meant that they wouldn't be able to get deported and that they could work in the United States while they had this status. What then happened was Texas was successful in that litigation to shut down the DACA program, and that shut it down for the entirety of the Obama administration. And then as soon as President Trump took over from President Obama, he immediately put the travel ban in basically on the first week of his presidency. And then we immediately saw state of Washington, state of Hawaii, and others spring into action to start filing these travel ban suits. And from there, it just became 4 years of this, which has now been replaced now again in the Biden administration by Texas and Louisiana and Missouri, now taking the place of California and Illinois and Washington and other states that were doing it. So I do think that's going to be the state of play. I do think it's easier, or the courts have made it easier for states to have standing than for other groups. And that's one of the reasons you see states suing a lot, is because the court gives them standing, whereas other groups won't have standing. But it'll be interesting to see, and I'll leave this for the other panelists, I don't want to monopolize it, with the court's limitation on who can get injunctive relief now, will states actually be able to continue doing this, or will they not be able to continue doing this? And that's going to be, I think, a question that will be decided relatively soon.
I also love that question for this panel, so we're going to bookmark that for sure.
Okay, sorry.
No, I love that. Karen, I think you had something to say too on this AG question.
Yeah, I think it's a provocative question. I would start by saying that if folks are interested in looking at the landscape of state challenges to the Biden administration immigration policies, you can visit our website because we're tracking that. It's justiceactioncenter.org and click on litigation tracker, and you can take a look at the large number of lawsuits that essentially seek to block at any move that President Biden is making to undo Trump policies on immigration or to create more immigrant inclusive policies. Like Leon said, states suing on immigration is not new. And I think it's important to be candid about that, right? Especially for me, I was part of those suits that Leon is talking about, right? And it was in fact, an intentional strategy to say it's important to immigrant communities to have their state, governor or attorney general and solicitor general stand up for them in court and say, this hurts our communities, we're bringing it to court. I think that what's different is not just the sheer number, and that's something you can kind of count, but the coordination on these suits, which I'll say more about in a second, and the severity of the results. So on coordination, like look beneath the surface level, it isn't just the state of Texas suing, right? It is the Trump administration in exile working for the state of Texas, right? We have Stephen Miller, Gene Hamilton, high-ranking Trump officials with very clear views on immigration that form a new legal entity that literally goes on the papers as counsel for the state of Texas. So that is different. That was not what was happening when Washington State or Hawaii were suing on the Muslim ban. And then the next is the outcome, meaning the remedy that courts are willing to order them. That is radically different. I think it's radically different because President Trump, whether you like it or not, was ruthlessly effective at nominating judges and justices to all levels of the judiciary. And we have seen the traditional remedy when you win one of these lawsuits is, vacate the agency memo. That's it. Go back, pick your pencils up, start again. But we've seen these incredibly expansive injunctions forcing negotiations with the government of Mexico, standing back up a program that's been closed for months and months and months, totally altering the agency's priorities. We've seen very aggressive judge-ordered, not even requested by the parties, data collection, even weekly data collection on the inner workings of the Department of Homeland Security. I think that is new.
Great. Yeah, very interesting. And I'm interested too in just the operational impact of, you mentioned I think you called it the severity of decisions from courts. So when it's not just vacating a piece of paper, when it is, or not just remanding a decision, but saying you need to go and negotiate with Mexico, reset up this program, or something else like that. What does that mean for a few different communities? What does that mean for the immigrants who are really in the crosshairs of all of this? And what does that mean for the government lawyers? Leon, I think that you'd have good insight on that. And also just for the folks on the ground at Border Patrol and the other agencies who are just having to kind of turn quickly to respond to the latest court mandate on their policies.
Who do you want to go first?
You go first.
Right. Yeah.
Okay. Me? Sorry. Okay. So for the government, here's the interesting thing. People think of the government as sort of this expansive, never-ending source of resources where there's a million people who can do everything. And the truth is, the government, even with all of its resources, has scarce and limited resources. And so the government in the immigration sphere can only really focus on one or two big things at a time. And so when these injunctions happen, they actually sort of not just end a policy, they divert everything that the government is trying to do with the normal operation of immigration policy to this issue of, okay, how do we resolve this court injunction? What do we tell the court? What do we do? So you take all of the lawyers who would otherwise be doing other things about the normal daily basis. Hey, what do we do about X case in a detention facility, X case on the border, X case with kids, just normal operation. They can't focus on any of that now because courts are telling them you have 48 hours to write a new treaty with Mexico on having appropriating people into Mexico. you have 48 hours to get rid of your prosecutorial discretion policy, which is one that I think we should be talking about in today's session, because that's unprecedented, that literally prosecutorial discretion, which is sort of like the easiest thing in the history of executive branch rights, is currently enjoined. You know, there's no prosecutorial discretion right now that's permitted. All of that diverts that. And so the implementation of that makes it impossible to actually run the agency. And so if that's your goal when you're filing the litigation, then sure, you're succeeding at that. But if that's not your goal, then what you're doing is diverting the most important resources of the agency from doing the work that the agency actually needs to do to serve the American people.
Ilya, you follow a lot of different areas of litigation beyond immigration. Is this what's being described about these pretty dramatic decisions from the courts? Is this happening in other contexts as well? Is it unique to immigration?
To some extent, certainly the trend of AGs suing to try to stop federal government policies that they don't like, that is by no means limited to the immigration context. It has been escalating for at least 10 to 15 years, probably longer than that, under Obama, under Trump, and obviously now under this president. And AGs on both sides, sort of the Democrats and Republicans, have become more active and also more coordinated in the way that they do things. And it's not actually that unique that they might hire outside experts or even lawyers to work with them on these cases. That has also become a more common practice, and they've staffed up their own offices, many of them, to have more in-house expertise in different areas. The issue of how broad the injunction should be or how broad the remedies, this also is something that has occurred in other areas as well. And there's a broader debate over whether nationwide injunctions, for example, are appropriate. I think they are, at least in some cases, but that there are people who think they're virtually never appropriate. And that's an ongoing debate. It's actually an issue the Supreme Court is interested in. It's not clear what they're going to rule on this. In terms of restricting the government on the ground, I think it depends on the injunction and what it does. And it's certainly true, there's sort of resource constraints in that, as the court actually recognized in the Remain in Mexico case, there's many more undocumented immigrants than the government can detain. On the other hand, it's hard for me to sit and say, well, they're strapping for resources when they can detain and deport hundreds of thousands of people every year. If it really was the case that sort of red state lawsuits that get injunctions or remedies, that they were just occupying the attention of the system and preventing it from doing its normal functions, in some case I might even say that's a good thing. They might not be able to deport and detain as many people as they otherwise could, but in reality there is a very large enforcement apparatus out there, and it does function even if the lawyers are busy doing other things. Obviously it cannot get to more than a fraction of all of the undocumented immigrants, but that's not much different from how we have a massive war on drugs domestically, to which the war on immigration can be analogized. And while there is a big law enforcement apparatus devoted to the war on drugs, it obviously still can't catch more than a small fraction of all the people who might use or acquire illegal drugs. And the same thing is true in this area. And some of our litigation that we've had both under recent presidents is precisely given that the executive cannot deport or detain more than a small fraction of the people at issue. There's tremendous discretion that executives try to exercise. And then people who are not happy about the way that discretion is being exercised, they will try to file lawsuits and argue that it's gone too far.
Aaron, can you talk about what it is like for the immigrants' rights lawyers who are working on these cases, and more particularly for your clients to kind of be watching this legal or regulatory ping pong?
Yeah, of course. And maybe I'll do that in the context of talking about DACA and, what happened yesterday. So, DACA, as most folks know, is a wildly popular policy across all sides of the aisle in the United States, has been for years. And yesterday was really a big nothing in the world of DACA, but not if you are one of the 1 million people who are DACA recipients or waiting to become DACA. So yesterday, after over a year, the Biden administration finalized a regulation on DACA. And, they announced that to great, attention by these 1 million folks who are my clients and class members in the Bataya Vidal case. And then we had to explain to them that the regulation essentially just makes the DACA program a fossil. It keeps in place completely, hermetically sealed, the 2012 eligibility and guidance for the program. We are rapidly approaching the time where no new people can age in or qualify into that program. It's completely doesn't fit the moment. It's a 10-year-old program that is transformative in the lives of my clients. It means that they are free of the toxic and chronic stress of worrying about being deported and ripped apart from their families. It means that they can pursue higher education, buy homes, feed their children, work with dignity, live to their potential, secure advanced permission to go to the funeral of a parent or a grandmother in their country of birth. It is simply transformative, but it's dated, right? Leon knows this. The eligibility of the program literally says you had to have been in the United States the day the program was announced, beautiful day, back in June 2012, and you have to have been here for 5 years before that. But if you're the same person who was brought to this country as a child who knows no other place is home but the United States, and you came in like, the next day, you're out of luck. Or if you were 30 years old in one day, the day it was announced, you're out of luck. And our immigration policy is supposed to be rational at a minimum. All of our policies should be, and it isn't. And so to have to explain to some of my clients and class members yesterday that after all of this work and that President Biden said, I'm here to preserve and fortify DACA, that not only has nothing changed, but if this rule will ever even take effect in 60 days is dependent on the red state lawsuit already ongoing from the state of Texas and what the Fifth Circuit does. And yet in the comment process, we had 16,000 comments submitted. 3% of those comments were opposed to DACA. And so my clients really wonder why, how can that be the case? Why hasn't Congress seen the need to get them out of having to live from court decision to court decision, have to count noses on the circuit courts, would they be for me? Are they not for me? It's no way to live.
Go
ahead, Ilya, did you have a
So I just wanted to briefly talk about what happened yesterday with DACA and how it fits into the broader picture of what's going on with DACA. That, as Karen said, DACA is a program that has very broad support and very strong moral and policy justifications, but it also has been legally controversial also almost from its inception. And there are several different kinds of arguments made against DACA. One is particularly relevant to what the Biden administration completed yesterday, which is the argument that this violates the Administrative Procedures Act, which says that for certain kinds of changes of policy, before you can make them, you have to go through this complex process known as the notice and comment process, where you give notice, you're going to issue a new rule or regulation, then interested parties, members of public interest groups and so on can file comments and the like, and the agency is required to consider them and consider various issues. So one of the arguments made in previous litigation about DACA and also the earlier broader DAPA DAPA program, the courts eventually struck down, was that this was illegal because they didn't go through this notice and comment process. I think, I'm not completely certain, but I think what the Biden administration did yesterday will insulate them against this particular argument, or at least it will greatly strengthen their position. People can still say, well, you didn't do the notice and comment process perfectly, or not every I was properly dotted or T properly crossed or whatever, but they have, I think, fortified themselves against this argument. On the other hand, there is this other set of arguments, which is not about the APA, which say that the administration just didn't have the authority to do this under the immigration laws at all, or at least didn't have the authority to do particular things like grant people permission to work. And I think here the weakest link in the administration's position is the part of DACA which says that people accrue lawful presence if they're in the program. Lawful presence is the technical legal term for something that actually doesn't give the immigrant very much, in that all it really does is that it accrues years in case the immigrant stays in the United States long enough to someday be eligible for Social Security and other similar benefits. And if they do become eligible, then they have more years which count in their favor. And however, lawful presence is the best argument that the red states and others have for saying that this is not just an exercise of executive discretion, but rather that it's trying to change the legal status of people. So I advise friends in the administration or friends with contacts there, maybe they should just drop the lawful presence part and keep the rest, because the rest is vastly more important as a practical matter. It enables people to stay and live in the United States, to work in the United States, to go to school. Whether they're accruing lawful presence is pretty insignificant compared to that. But yet this is sort of the biggest Achilles heel when this issue goes to court. This is the thing that people always fasten on because it's legally more vulnerable, and also because it sounds bad. It sounds like you're changing the law, even if you're really not. So to the extent that some of you listening or some of other panelists have influence over this, they can help themselves and make it more likely that they can preserve the program if they drop this one vulnerable element. But ultimately, to really preserve it in the long run, including against future potentially hostile administrations, it would require congressional legislation, I think. And I think most other legal experts would say that as well, that an administration that really wanted to unwind DACA and did it more competently than the Trump administration tried to do it, because Trump and his people were often sort of ramshackle about the way they did things. If an administration wanted to do it badly enough and did it competently enough, probably could do it.
And for any of our viewers who aren't up to speed on the DACA litigation, the current status is that the Fifth Circuit is due to issue a decision probably sometime in the next few months that will weigh in on the legality of the program. And then most people expect it will go to the Supreme Court, and the Supreme Court will have the final say on its fate. And we'll see whether Congress steps in at any point before or after. I want to zoom out for a minute and talk about, we've got all of these cases happening in the federal district courts, the appellate courts, at the Supreme Court. Are the judges who are presiding over these cases exhibiting good understanding of how immigration policy works, of how border security deterrence works? And if not, what is the legal community doing to educate judges on this? Is there anything they can be doing? I want to go to the litigators first on this. Maybe Karen, if you want to start.
Sure, it's a great question, and I would have to say it's a real mixed bag, and it depends often on the speed of the litigation. That may change for reasons, especially that Ilya talked about, this big change in terms of whether injunctions will be able to issue on a kind of a temporary restraining order basis or a preliminary injunction in some of these cases. Here's a couple of examples of what we see gets missed in the district court cases. And it's hugely important, right? Because the district court is the fact finder. And if the facts aren't properly laid down in the record, then the courts on review are, their decisions are less likely to be valid. So first, what I see that gets missed is it's horribly complex to understand the statistics and the different categories of people entering the United States and what happens to them. It's particularly complex in the COVID era when we have had these kind of dual policies, both over Maine and Mexico, and Title 42, which has essentially been turning around entrants at the border. And we've seen an incredible number of repeat entrants in a short time period. So sorting that out and what even does the actual government data mean and what can be extrapolated from it, that's a mistake that we see time and time again. The second issue that we see a lot in these cases is it's this square off as if it's a preemption battle when it's not. It is the states versus the federal government. And what gets lost in that, that's great. That's hugely important. Both of those actors have important interests at stake. But what's lost there is the people, right? There is actually no one tasked in that equation of talking about the human impact of what is being asked of the court, right? It isn't the role of the United States Department of Justice to talk about what is going to happen to the individuals. They need to talk about, right, their resources, how they're expended, and that gets lost in the shuffle as well. So what the advocacy community is trying to do is, number one, keep abreast of the changes. That's why we created this litigation tracker, right? The courts have to be accessible. If the courts are changing our rights, which we've seen so profoundly in the last months, it isn't just an issue for lawyers, right? If we can't understand what's happening in the courts and how quickly we can't advocate. So through primarily amicus briefs, sometimes intervention, you will see immigration advocates, research experts trying to fix those data errors that I was talking about originally, and also ensuring that voices of impacted people are brought to the judge so that as they weigh what is happening, they have some sense of what their decision will mean for many years to come.
And just building on what Karen is saying, so when you're in this litigation, it's fascinating because I would say there's two kinds of immigration lawyers or advocates or judges. There's what I would call code heads and non-code heads. And so a lot of times the litigation is happening between code heads. The Department of Justice has an Office of Immigration Litigation, who that's all they do. They do the immigration code. They're the code heads. And then the advocates are highly specialized now. There's Karen, there's the ACLU, there's all kinds of other organizations, and they're code heads too. They know the code just as well as the Office of Immigration Litigation. At the same time, the judges are not code heads. Whether you start from the district court, the Court of Appeals, or the Supreme Court. And oftentimes you'll watch these Supreme Court arguments and you'll see it. I mean, it's a huge disconnect between even what's in their opinions and what's being discussed in the oral argument, because the opinions are immersed in the code. Somehow they get there, but that's not what the oral arguments look like. And so a lot of times you are in a very delicate situation, whether you're an advocate on whichever side you're on, of trying to make sure it gets grounded in the code, because you don't want a decision that's not grounded in the code. But a lot of these decisions are going all over the place that have nothing to do with the code. And that's one of the frustrating things about this litigation, is you really see it depending on where the litigation is and what it's about, that it's hard to then harmonize things and make them consistent. And this, I think, is becoming more fraction rather than less fraction. That's number one. And then number two, an interesting point that Karen makes about statistics. I'll just give an anecdote. I used to love statistics. And then when I was at the Office of Immigration Litigation, it only took like 6 months where I just saw us, every time we used statistics, we'd have to go back to the court and say they were wrong. I beg the lawyers, no more, unless a judge is ordering you to give them statistics, don't give any statistics. And if they ask, say, look, we should focus on the code, these statistics are complicated and everything. And I don't think that's changed. And it's not, some people think it's, what's it called? There's some sinister aspect to it, but it's not. It's regardless of the administration, just for whatever reason, the statistic keeping never is accurate. And it's one of those things that plagues the litigation, because the judges are so intent on wanting to know what's going on. And the advocates want to know, and the government wants to know what's going on. Everybody wants to know. But the fact that we have these statistics that people rely upon as gospel, and they're basically always wrong. I wish I could gamble against the statistics. I'd be a billionaire, because they're always wrong. And it's not on purpose. Really also makes the litigation complicated, because we just don't know what's going on a lot of the time.
I wonder, since I've written a little bit in my academic work and sort of this question of the role of expertise in government policy and how it should operate. In one sense, it's definitely true. Most federal judges are not experts in immigration. It's not the issue they most follow. And that's also probably true of most state government officials as well, state attorney general and so on. On the other hand, we increasingly see repeat players in immigration litigation. It's often the same state AGs that file sort of right of center cases under a Democratic administration, and another group, but also repeat players who file left of center cases under a Republican administration. They often also have their go-to forum shopping judges. They know which district to file in, where they hope to get a judge that's sympathetic to them. So Judge Andrew Hanen, who was mentioned earlier, who's a very conservative judge who generally rules against the pro-immigration side. The litigators on that side know that when possible, they try to file a case that will get into his court. During the Trump administration, sort of the pro-immigrant side had their own go-to locations, which were definitely not Judge Hanen. So there are downsides to this, but there also does mean that there's more and more repeat players. And to the extent that more of these cases get to the Supreme Court, they become more repeat players as well. So it was notable in the Remain in Mexico case. If you look at Chief Justice Roberts' opinion, what other majority justices said, there actually was a lot of discussion about sort of the practicalities and how it's not actually possible to detain everybody, no matter how much some people might want to. And also the issue of negotiating with Mexico came up as well. So knowledge will increase over time and has already increased with all these repeat players, but whether that will improve the quality of legal decisions in this area, I think remains to be seen, because I do think that part of the repeat playerism and knowledge is that many of the repeat players are ones that are not simply weighing the evidence in an objective way, but they're repeat players because they already have very strong commitments. And so more knowledge may simply just give them additional ways to argue for the things that they already believe in, as opposed to improving decision-making quality. But maybe at least at the margin, it will improve as well.
That makes sense. Yeah, I want to move to some audience questions now. As a reminder, you can ask a question on the chat function on YouTube or on Twitter with the hashtag live. And we've already gotten a lot of great questions. So let me start with one that we got from Joel Miller. Thanks for sending in this question. He asked, how feasible would it be for the federal government to guarantee meaningful legal representation in immigration proceedings? I know this is moving us to a little bit different area of the immigration law space, but I'd be really interested to hear if people think that that's something that's really possible.
Karen, you want to start?
I'll start. That's so funny. I was going to have you start, but yes. So here's what I think, and I'll give a concrete example. Of course, I think it's possible. It also would be a game changer in terms of outcomes and ensuring that we don't have arbitrary outcomes, where the difference really between whether you are able to stay in this country and not is, were you able, because of access, because of where you are in the country, because of your family's connections, to secure an attorney, right? So it would really stop what we call immigration roulette, where the same case wins one time and is denied another time. The government is able to rise to the occasion when they want to. And so in the immigration space, we saw this same administration figure out how to humanely and quickly welcome 26,000 Ukrainians within a 2-month period. While at the same time, we have seen this administration expel 26,000 Haitian immigrants over their entire time in office. So the difference is when there is the will and the motivation to get it done, it can be done, it can be built. This is a competent, it is a moral, it is a compassionate administration. But when you lack that, it cannot be done.
And what I would say is this: I think there are slices that you should at least start with. So yes, kids was the first, why not start with kids? I mean, obviously there's a money situation there, but I think you can divert funds that are spent on other aspects of the immigration machinery to divert it to right to counsel for kids. And by the way, one of the biggest misconceptions of this issue of right to counsel is that this is somehow going to make the system function in a choppier or lengthier way. In fact, we spend so much time with continuances and reopening cases because of incompetence and bad judges who did the wrong thing because there was no lawyer there, et cetera, that you end up with that, even if it takes a little longer, because you have a judge, you have a lawyer, and the lawyer prepares the case and everything else right at the beginning, you end up getting more finality in all of these outcomes because that's it. The person was represented by counsel, they went through the decision, then they have it. And that's the one thing I would hope that, as we're doing a bipartisan policy center thing here, that argument, which I've tried to prevail upon conservatives for years, is that this will make the system go faster. People think, no, it's giving free taxpayer money to undocumented people. No, it will make the system go faster. So that's where I think if we could get that argument to more people and they would understand that, I do think that you'd see that counsel more.
So just a couple points on this. Obviously, some of the other participants know much more than I do about sort of what happens on the ground with this. But I would note just a couple of things. One is, at least initially, if you greatly expand access to counsel, as I believe that we should, it would cost some resource. I think there's no way around that. You're not going to get enough lawyers to work for free to make this happen. On the other hand, in the medium to long term, there would be some real savings. One is, if the government knows that they would face an actual counsel with serious legal representation, they can take account of that in their decision on what to do in the first place, that it would be less likely to initiate a dubious detention or deportation, and we would save money on those operations that are foregone. The second is that if, as a result, more people be able to stay in the country and work, they would productively contribute to the economy. Over time, the extra resources from that, including even the extra tax revenue, I think could easily outweigh the expenses of additional representation. That I think in the short run, there would be some expenses, there would be some issues that arise from it. I think that happens anytime historically when some set of rights have been neglected, and then there's a change to try to end the neglect or at least diminish it. When racial segregation was legally ended, there was an upsurge in litigation over issues of racial discrimination. But over time, a new equilibrium sets in. Both the government and private parties have a better sense of what their rights are, and we can save resources through that directly, but also indirectly by having more productive people come in and reign and stay, and thereby contribute to our economy in ways that can easily offset sort of extra litigation costs and lawyer costs. So I think that's important to try to keep in mind here.
Another audience question. It's going to have to be a bit of a lightning round. We've got about 4 minutes left. So thanks everybody for participating and sending in so many questions. We wish we could have gotten to all of them. But this question is just, what do we need to be keeping an eye on in the courts, in the lower courts and the Supreme Court in terms of big immigration questions that come next? This gets back to what we started on in this discussion, that the courts have taken on some big questions recently, but also opened up new ones. We know they may be looking at DACA in the near future. We know they will be looking at immigration enforcement priorities. So what else should we be keeping an eye
on? The ones that cause me to not sleep at night are Plyler versus Doe, which is, will kids who are undocumented not be able to go to public school anymore? Look for that one. And Arizona law, will that get reversed to allow states to enforce immigration law? I think those are the two big ones people aren't looking at, and I think those are that's like the big tamale of immigration law, is if those are overturned, then that changes everything on immigration law.
Extra point, the next person can get in a food analogy. Big tamale.
Yeah, I just want to add on what Leon said, right? Why are those two cases at issue? They're at issue because of what we saw of the overturning of Roe versus Wade and of Dobbs. And shortly they're at, like, Leon is talking about settled old Supreme Court cases. And as soon as Dobbs came down, not very shocking, the Attorney General of Texas said, I want to challenge and reverse Plyler versus Doe. I want to change the rule that we don't discriminate in our elementary schools about what the child's status is. And I want to change the rule. And it really is on immigration enforcement of whether states can stand in the shoes of the federal government. The last thing I think people should keep their eyes on, that they're not, is the use of parole and back to mandatory detention. So parole matters. It is, as Leon had said, maybe it's a conehead issue, but parole is letting someone into the United States because of a significant public interest is kind of the primary test, but it has functioned as our asylum system was shut down under President Trump. And so what happens there is a big question. And if you're concerned about DACA, you better be paying attention to the ICE Enforcement Priorities Memo, because it will be tested first before DACA gets back to the Supreme Court.
Leah, do you have a 10-second answer for us?
Yeah, so obviously the DACA case is significant. Also, any case that might bring up the issue of non-delegation or major questions in this area, and also the enforcement priorities case, which there's litigation making its way through the courts on whether the Biden administration can change enforcement priorities for deportation relative to Trump. There already has been a pretty strong ruling on this by the Sixth Circuit, with Judge Sutton saying they can make the change, but I think the legal fight over that issue continues. And obviously there's plenty of other issues as well that in the 2 seconds left, I probably don't have time to go over.
Lots to watch. Thanks everybody for participating in this conversation, to our panelists and to the Bipartisan Policy Center for putting on this great conversation, and to our audience for listening in and sending questions. You can find us all on Twitter, so please stay in touch, and we look forward to continuing this conversation in other spaces.